If your spouse earns way more money than you do, or they're capable of earning way more money, are they going to win custody? When judges decide child custody, the judge has to review which parent's more capable to provide for food, clothes, and the cost of care for a child. Let's unpack this issue. I'm Jim Craveld, lead attorney at Craveld Family Law, and our team of attorneys have been taking countless child custody cases to trial. And during each trial, the judge will have to review each parent's income and their capability to pay for whatever expenses are necessary to raise a child. If your spouse has more money, well, he or she is more capable. That's true, but let's dig a little deeper. When the judge decides child custody factors, the judge has to review 11 factors and, regarding each factor, determine which parent wins that factor. Sometimes, the judge may find that parents are equal on a factor. These factors are commonly called the best interest factors, and they're outlined in MCL 722.23. I have other videos about the other best interest factors. If you haven't watched videos on factors A and B, go back and take a look. This is factor C. The judge is going to evaluate your case on all 11 factors, so even if you fare poorly on some and really well on this, that doesn't mean that you're going to actually win. There are 10 other factors that you have to prevail on, at least be equal or better than. Factor C, the third factor that the judge reviews, requires the judge to review the issue of your ability to pay. They're going to look at two things. First, the judge will review each parent's capacity or ability to provide for the basic needs. And secondly, the judge is going to look at the disposition or willingness to provide for those needs. So the focus is on ability and willingness. So let's talk ability. Regarding the parent's ability, case law provides that the judge can look at the difference in income. For example, there's an old case, Carson v. Carson. The husband earned approximately 4 times as much as his wife, and because the wife had just recently started her job, the court ruled in favor of the husband on that factor. On the other hand, in LaFletch v. Ibarra, one of the spouses was employed, the other spouse was unemployed, but received unemployment benefits and child support payments. The court found that the parties were equal on this factor. So, ultimately, when you're not employed and your spouse is, you could assume that, well, you have a bigger uphill battle on this factor. But the judge is going to also look at your willingness or disposition to provide for your child. So, ultimately, when the judge looks at your capacity or ability to provide care, the subject can be reviewed pretty easily. They'll want to know how much you earn. Do you have liquid assets? For example, a bank account with a lot of cash. What kind of money do you have to pay for day-to-day expenses? When it comes to your disposition or willingness to provide care for your child, we ought to dig a little bit deeper to see what the judge is going to look at. So, some questions you could ask yourself. Do you voluntarily earn less than you're capable of earning? Did you recently become self-employed or underemployed? Have you incurred large debts that require monthly payments? Do you support other people, for example, an unemployed boyfriend or girlfriend or adult children? Since separation, have you been paying your support or contributed financially to the children? Have you taken the children to the doctor, dentist, and paid for all those bills? Which parent has been buying the clothes, the school supplies, etc.? Which parent's been scheduling the doctors and dentist visits? If your child has special needs, who's made modifications to the home? Who's made accommodations for the child's needs? If you're faced with an upcoming custody trial and you need to prepare for this factor C, there's a few things that you can do to do as well as possible on this factor. For example, if you have unpaid bills for your children, such as medical bills, you may want to pay them off as quickly as possible, or at least enter into a payment plan. If you haven't scheduled dentist or child checkups for a while, do so as soon as possible. Try to get that first appointment in before your end of the investigation is started, or for sure before trial is started. If there's a claim that you're not providing enough food or not healthy food, save your grocery receipts. Show what you buy each week. Take pictures of what's in your fridge. So, you should be able to, so you should create and be prepared to present a budget based on your paychecks. What do you spend on housing, utilities, groceries, insurance, educational expenses for the kids? If you have the financial means, open a 529 savings account for your children's college expenses. In conclusion, the judge will really attribute a lot of weight to each parent's disposition or willingness. A parent who earns minimum wage but takes the kids to the doctor's appointments, uses food stamps to buy healthy groceries, goes to the library to obtain educational books, will beat out a parent who earns $200,000 annually but fails to pay child support. I hope this brings you one step closer to doing well on your custody trial. As always, if you have questions, contact us or any other competent family law attorney. Until next time.